petition was submitted, and the Honorable Supreme Court, Honorable Division Bench of the Honorable High Court held that since he has been convicted at two places by a learned court at Rajasthan and a learned court at Ahmedabad, therefore this parole cannot be granted. Hence, in this petition, we have challenged the validity of the rule itself. May I read the relevant portion at page 268?
Yes.
Irrespective of whether such provision is unconstitutional or the law as it stands today, bars consideration of the application of the prisoner who is undergoing jail in Rajasthan, having convicted by a court of other state. Thus, there is a clear prohibition under the law. Therefore, prayer to read down Rule 1, Sub-Rule 3 of the new parole rules of 2021 on the basis of the judgments rendered earlier. All judgments have been referred, and thereafter the next page, the last sentence.
Yes.
The petitioner could seek the consideration for release or parole under new rules of 2021, nor any direction can be issued for grant of first parole of 20 days under the new parole rules of 2021. Therefore, sir, my respectful submission is, when first application was rejected, the Honorable Court said that the rules do not permit. Hence, in this writ petition, particular rule has been challenged. In the previous rules of 1958, the expression was, ordinarily, if a person is a resident of the outside state or is convicted by a court other than the state, then parole can be granted, but the expression ordinarily was there, which is conspicuously absent in the new rule. Therefore, in view of this judgment, the superintendent cannot consider my case. What to talk? Even the High Court said that we cannot consider. Therefore, we are challenging. This is my second prayer in this writ petition, that the rule may kindly be declared ultra-virus on the ground that it is making a geographical discrimination. I have various grounds of challenge. That is a question of the liberty of a person and the treatment of the person who is in a critical condition. This issue that my learned friend is saying earlier considered, should go there, has to be considered on a higher pedestal.
Yes. Yes. Yeah. This rule is challenging now this rule. Because two situations parole cannot be granted. One is conviction by court martial or a court of other state. Suppose there is a conviction in case of this state and another case in other state. Then the question is whether this court cannot grant a parole for the conviction in respect of the state here. We may not grant a parole for the other case where he was convicted.
In this case, we leave him for treatment of heart, which is claiming, then that parole has to operate.
Parole, we can't grant in respect of conviction of other state. But see, once we grant parole here, situation, no, you can seek a parole there.
Sir, therefore the rule is under challenge.
There is a question.
No, it has been.
The parole is not on merits. We have to examine whether there is a medical condition or not.
That is different.
If the medical condition is acute for A, B, C, D, whoever, then, and if we are granting parole, will it not operate for all purposes?
No, medical condition exists, but he wants a different condition. We don't.
So that can be dismissed. In case we find that the treatment is not required, then we can dismiss it. But then this rule seems to be a little arbitrary.
No, he has to satisfy the validity of this. No, as per the previous rules, previous judgment, only on the ground that conviction is involved in other state. So rule prohibits the application of.
So now that time the rule says it is challenged and just hear him at length, whatever will happen, will happen.
The thing is, he has filed a GP, putting in maintain application. But this is locus. Anyway,
we'll hear him on everything, whatever. Meanwhile, a status report can be called so that both sides are prepared and we can hear them. We decided finally,
If you
allow me dismiss.
if you see the other cases where multiple times paragraphs, there must have been obtained reports.